So welcome back. Let me just introduce our three speakers on this panel. From beginning at the far right, Jamal Greene from Columbia Law School. And I should add, this is our Publius Symposium, but we usually do this around a noted book that has just been published in the preceding year. This is the first time we've ever done something from the deep past, like 40 years ago. Last year's Publius Symposium was on Jamal Greene's book called How Rights Went Wrong. Then on his left, Nathan Chapman, well known to this organization since he was the executive director of the Constitutional Law Center for several years, now teaching constitutional law at the University of Georgia. And Zach Price from Hastings, just up the road. Zach was also a fellow here for 1 year, maybe. So we can't take as much credit for what he's about to say. But anyway, welcoming the three of them, take it away.
Okay, thank you, Michael. I think we're going to go in the order that Michael just said. So I'll go first, and we'll head down the line. I'm going to take this opportunity to first thank everyone for coming, and thank the Constitutional Law Center for inviting me to this celebration of this book, because it's really an extraordinary book. I still think that no book of constitutional theory, of U.S. constitutional theory, has bettered it, even in the 40 years since it was written. Maybe that's because of what Larry said, and no one's really trying anymore, but we'll see. But I want to offer not quite 3 cheers, but 2.5 cheers for democracy and distrust. John Hart Ely has very profoundly affected my own thinking about constitutional law and about the role of judges within the U.S. System. And as others have noted, I think it's fair to say that all serious thinking about judicial review in the United States, at least at the grand theoretical level, has to engage with Ely and his dual critiques of what he at the time referred to as interpretivism and non-interpretivism. And indeed, I'm going to argue that each of those critiques endures to this day, and that each remains as difficult to answer as they were in Ely's day. I settle on 2.5 cheers because I think his affirmative answer to the problems of interpretivism and non-interpretivism, while elegant and sophisticated and, as I said, in need of an answer, is not quite adequate. As I'm going to try to explain, I do think Ely is onto something in focusing on distrust as an important trigger for robust judicial review, hence the half star, so you get more than 2, but 2.5. But at bottom, the role of judges within our system is not just to sit as guardians of democratic politics, but is rather to sit as guardians of our constitutional values, some of which are inconsistent with democratic politics of a particular time or place. Sometimes judicial review requires leaning into and defending healthy democratic choices, and sometimes it requires something different from that. So I think Ely was correct in saying that playing that role, the role of a judge in a democratic system, does not rest easily on textualism. And it also does not rest easily on abstract moral philosophical thinking. But the idea that it rests solely on an evaluation of democratic process failures, I think gives up too easily. Ultimately, in my view, the key to the ability of judges to play this role without succumbing either to the false certainty of interpretivism or to the anchorlessness of what Ely called non-interpretivism is, in short, what I'll use the exotic phrase used in many other constitutional systems, proportionality. Ely's basic critique of interpretivism is, to my mind, indisputable. The constitutional provisions that we argue about the most are the Due Process Clause, the Equal Protection Clause of the 14th Amendment. Neither provision gives any textual guidance on how to resolve modern controversies around equality or around fundamental rights. Even if we were to rely on the Privileges or Immunities Clause, as many originalists do, the open-ended nature of the language of that clause likewise does not lend itself to textual specificity. Moreover, even if we were to be able to use the text to determine exactly which rights are included, whether it's rights to contraception or rights to child rearing or right to vote or what have you, the constitutional text gives no guidance on how, if at all, these or any other rights may be limited. Modern conflict over rights is not, by and large, conflict over whether particular rights are constitutionally protected. It's about what the scope of those rights might be, and what one does when those rights encounter other rights or other democratic or constitutional imperatives. So if we switch from just a kind of specific textualism to originalism, it also doesn't adequately respond to this challenge. The original textual meaning of vague provisions does not give guidance on how rights may be limited or on what modes of interference are permitted. Relying on original expected applications, which is kind of out of favor, is arguably inconsistent with the text itself and is in any event usually underspecified, if not internally contradictory. Now, more broadly, and to my mind most importantly, originalism offers the worst possible response to the problem that the Constitution's drafting and ratification was largely done and has been done by people who did not represent the majority of the population at the time, much less today. Now, what about non-interpretivism? Ely defined non-interpretivism as the idea that, quote, courts should enforce norms that cannot be discovered within the four corners of the document. And Ely's problem with this is that it amounts to judges imposing their own substantive values. As John McGinnis and Michael Rappaport have emphasized, constitutionalizing values has, through the kind of supermajority rules that are typical of constitutions, offers the great benefit of transparency about which values are the ones large numbers of people have actually agreed to. Moral philosophy about what equality requires, whether of Dworkin or of Adrian Vermeule, does not enjoy this transparency or this democratic pedigree. And as we've heard today, Ely's response to the challenge of interpretivism on the one hand and non-interpretivism on the other is to ask of judges that they spring into action when they detect failures in the democratic process. The Constitution positively protects process, right, at several turns, Ely tells us. And lawyers have a comparative advantage in recognizing failures of process. Ely's explanation for why this is not very elaborate. He just sort of says in one of his famous lines, observe any lawyer at a public meeting, and you'll see. Emblematic of those failures are as we've heard, the second and third paragraphs of Caroline Product's footnote 4, which respectively address choking off the channels of political change and infringing on the rights of discrete and insular minorities. Now, there is something to this, namely, distrust of the democratic process as genuinely democratic or representative of the population seems to me an excellent candidate for the sort of circumstance that should cause judges to carefully scrutinize democratic outcomes. But importantly, as Bruce Ackerman and public choice theorists and many others have helped us to see, democratic distrust is empirical and contingent rather than conceptual. Sometimes it involves infringing the rights of minorities. Other times, infringement on the rights of majorities might be what we find suspicious. Sometimes it involves discrete groups. Other times, those groups might be anonymous or covert. Sometimes insularity might reflect democratic incapacity, and other times diffusion might hinder democratic engagement. With that significant qualification added, the qualification that we're talking about something contingent rather than something conceptual, Ely is right that a democratic process failure should be a factor in giving more scrutiny to the actions of legislators, but it shouldn't be the only factor. Because judges are engaged in constitutional review and not just democratic review, their degree of scrutiny should match the degree of infringement on constitutionally protected rights. Now, of course, the problem is, how do you figure those out, right? Without getting too abstract? Well, in determining how judges should constrain themselves, in deciding when and how the broad provisions of the Constitution are engaged, U.S. courts can and should, I think, accept the guidance of the many courts around the world that face similar challenges. The key move globally has been to shift away from viewing constitutional rights conflicts as primarily interpretive problems, where determining that a right is engaged leads to some necessary consequence in some dispute, and to shift towards viewing rights conflicts as problems of optimization, problems of optimizing constitutional values that inevitably will compete with one another. This ultimately means de-emphasizing whether the broad language of the Due Process Clause or the Equal Protection Clause supplies a right, and instead devoting more resources and lending greater intellectual primacy to the much more contextual question of when and how the government is permitted to interfere with rights. This means, for example, we heard about campaign finance. In a campaign finance case, the primary question should not be, for example, whether corporations have speech rights, right? But instead should be focused on the degree to which a particular regulation strikes at the core or at the margins of the values that free speech is meant to protect. In a case about objections to same-sex marriage by cake makers or web designers, which we also heard about, the question shouldn't be whether artists generally get an exemption from anti-discrimination law. It should focus on the particularities of weddings and cakes and web design and the nature of the artist's objection, whether religious or something else. It should train on the particular exemption sought, the particular law at issue, the particular harm to the parties, and how much that exemption burdens the law's objectives. This might in turn require not just an assessment of the burdens on particular litigants, but also an assessment of the values that the government is trying to promote in passing a particular piece of legislation. Those values might also exist in a constitutional register. It requires an intensive assessment of the particularities of legislative or executive action, as well as the available alternatives to achieve comparable objectives. These are not abstract philosophical questions. They are mixed questions of philosophy and fact, in which the factual presentation of the case is what grounds the philosophy and the sorts of judgments that judges have any business making. These are also not, and this is important, these are also not permanent distributions of the costs and benefits of rights protection. The judgments that they require of judges are always contingent. They are always temporary. They are always dependent on facts that could change as circumstances change. The important question on this view is not whether a right is engaged. Rights are always engaged. The question is rather whether a right is respected. We respect rights by taking them seriously, not by having them win out in some particular conflict. The lack of permanent settlement is what judicial review under conditions of constitutional pluralism requires. Under this approach, our common law can be one that builds out the law according to material conditions, empirically grounded justifications, and evaluations of policy alternatives, as opposed to building out the law through abstract legal categories, such as strict scrutiny, or content discrimination, or disparate impact, or indeed discrete and insular minorities. At bottom, I think it will serve us well to develop a set of judicial practices that recognize and build upon the essential compatibility between respecting rights and individual litigants, sometimes, maybe often, losing their cases. This is consistent, I think, with Ely's broader focus on judges as guardians of the democratic process, but with a twist, because the democratic process is not just about voting in elections. It's about contributing to a democratic culture. It's about developing our moral and political norms through free and equal participation in a culture of rights definition and contestation. It means that judges have to account not just, as I said, for the rights of the aggrieved litigant, but also for the rights of those citizens whose rights are being protected legislatively rather than judicially. Judicial review isn't just about stepping in when electoral politics are not deserving of trust. It's about enabling those of us who are not judges to be active participants in constitutional self-definition. Nathan.
Thanks, Jamal. And I want to join Jamal in thanking Michael and Morgan for including me. It's a real honor to be here, to see some old friends, and to talk about this interesting book that's influenced so many of us. Today I want to make two somewhat unrelated arguments. The first is that Ely's book is so successful because he was a master of a particular tradition of moral inquiry, one about judicial review. If you situate his book within this tradition, it's easy to see why he's successful. It's also easy to see why it's inevitable that he's not going to persuade everyone. The second argument is that Ely's book would have been even more persuasive had he paid closer attention to the Constitution's religion clauses. Well, let's start with the meta theory. Imagine you're a judge in the early republic. You get a case where a state legislature ordered the retrial of a will dispute. The party who won at trial argues that this act of the legislature violates the Constitution's prohibition on ex post facto laws. Some of you will recognize this as Calder versus Bull. What are you to do? Any 21st century lawyer knows just what to do. You use the Google, and you find out whatever the Google says, a law dictionary says about what ex post facto law means, right? You try to figure out maybe what it meant in the early republic, what other cases have said about it. You quickly learn, of course, that the primary authority for the proposition that an ex post facto law refers only to a criminal law or punishment is attributable to Calder versus Bull, and so on. But you're presuming a great deal that was in fact contested in the 1790s. What makes you think that you have the authority as a court to invalidate a state law in the first place? If so, what makes you think the text of the Constitution should be the focal point for determining the contents of constitutional law? What if there are natural rights the Constitution does not spell out because they're so obvious to everyone involved? And you're hearing some echoes of what Larry talked about earlier. As a 21st century lawyer, you're breathing the air of a tradition of what I'm going to call moral inquiry that crystallized over decades and even centuries. I'm not saying it was historically inevitable, it wasn't, nor did it emerge fully formed and battle ready from the head of John Marshall. It's an ongoing contest over the proper bounds of judicial review, about what judges should do when they confront a constitutional question. I'm building on the work of philosopher Alasdair MacIntyre and legal theorist Jeff Powell. What I'm talking about is not just an intellectual history of theories of judicial review. It's a theory about what makes those theories coherent and irresolvable, about what makes some of them better than others, and what makes the entire enterprise meaningful. So what makes this a tradition? It's a combination of commitment, problematics, and contestation about how to resolve them. I'm going to use the word problematics as a kind of term of art just to distinguish it from problems. The foundation of the tradition is a shared commitment to three principles that emerged in the first few decades of the New Republic. The first is that the written Constitution is the principal, if not the only source of constitutional law, at least law that judges will enforce. The second is that what gives the Constitution authority is the will of the people, or popular sovereignty. The third is that because they are enforcing a higher law enacted by the people, courts have the power and duty to declare conflicting acts of the government unconstitutional. Three shared commitments. I'll call them writtenness, popular sovereignty, and judicial review. The combination of these commitments creates conceptual problematics with grave practical implications. the problematics cannot be resolved all at once. It's like a whack-a-mole. If you resolve one of them, the other one pops up. So one reason Ely's theory is so powerful, I argue, is that he's candid about the existence of these problematics. I think he's somewhat less aware that their resolutions are mutually exclusive. So the writtenness of the Constitution produces indeterminacy. Putting things in writing has at least the possibility of reducing potential disputes about meaning, but it can't eliminate them altogether. And as Ely explains, many hard constitutional cases are hard because the applicable provision is vague, ambiguous, broad, open-textured, whatever you want to call it. Ely was writing before the rise of originalism, but he might have added that evidence of original meaning, though it may reduce some textual indeterminacy, can't eliminate it, and sometimes it actually makes matters worse. The indeterminacy of the written Constitution is our first problematic. The commitment to judicial review, however, means that judges have a duty to decide constitutional cases. They can't just take their gavels and go home when they run into an indeterminate constitutional provision. So when the constitutional provision is indeterminate, where should a judge turn for a source of normative constitutional values? On this point, I think Ely was especially devastating. Values are inherently subjective. When judges rely on natural law, tradition, contemporary consensus to overturn a policy decision made through a fairly tuned democratic process, they effectively exchange popular sovereignty for their own preferences. This is what Alexander Bickel, to whom he was principally responding in Democracy and Distrust, famously called the counter-majoritarian difficulty, and it is our second problematic of our tradition. Bickel, of course, didn't identify the counter-majoritarian difficulty. I think James Bradley Thayer, writing in the late 1890s, was the first to really start to hash it out in response to what the Lochner Court was doing. So this is one place where Larry's kind of narrative of the tradition of judicial supremacy is a little different than what I'm talking about with the tradition of judicial review, which is just what should courts do when they run into a constitutional question? One answer is they should ordinarily defer to what the democratic process has produced. As Ely recognized, though, the people, through the Constitution, sought to bind passing majorities. Right? Declining to enforce the Constitution against democratically enacted policies can lead to what some theorists have called the tyranny of the majority, or what Ely probably would have called a tyranny of the political ends. That is, those who've inherited political power, often through a democratic system itself that was malfunctioning. The tyranny of the political ends is at odds with the tradition's commitments to popular sovereignty, because remember, the people wrote the Constitution, and with the people's decision to restrict future brokers with that written instrument. Many theorists have used the problematic of the tyranny of the majority as an opportunity to rely on source of substantive values that Ely dismisses as too subjective and therefore too much of a threat to self-government. Moral reading theorists like Dworkin do it, and originalists like Randy Barnett do it too. He just simply supplements indeterminacy with his preferred value of libertarianism. To my mind, however, I've never seen a satisfying response to Ely's case against relying on extra-textual values to interfere with fairly enacted policy. So Ely, despite his fulminations against interpretivism and his obvious concerns with political self-dealing, errs on the side of popular sovereignty expressed through a written constitution excuse me, and the ordinary political process, and against the imposition on society of substantive values divined by a judge from supposedly neutral sources. By purporting to resolve the problems of textual indeterminacy and popular sovereignty in the name of representation reinforcement, though, Ely leaves himself open to the charge that he has capitulated to the problematic of the tyranny of the ends, or, to put it more blunt, injustice. Right? So Ely leaves himself open at the same time to textualists. His major constructive contribution of the tradition of judicial review seeks to navigate the shoals of the counter-majoritarian difficulty and the tyranny of the political ends with judicial intervention to protect the channels of democracy and to ensure fair political representation. In this, he improved upon his process theorist forerunners, I think, which tended to think the constitutional structure and democracy would look after themselves. He rightly identified malfunctions in the political process that the process itself could not fix, malfunctions like discriminatory motives that would pervert popular sovereignty. And he argued forcefully that the Constitution itself, understood in whole and in light of its original interpretive history, gave ample justification for representation reinforcing judicial activism. It is not that his account is untextual, it is scrupulously textual. It's just that he is willing to make inferences from the text about judicial review that a judicial conservative would reject. The moral tradition framework lets us see why Ely's theory is so successful, but also why neither it nor any other theory can entirely resolve the problematics. In fact, the moral tradition framework makes the objections to Ely's theory obvious. Right? Those especially concerned about the tyranny of the majority will take issue with Ely's deference to the political process on questions of value. In other words, it tolerates injustice. Those who are especially concerned about judicial subjectivity will take issue with his representation reinforcing activism as being no more grounded in the constitutional text than the values he rejects. In other words, his approach to judicial duty and textual integrity is ultimately unprincipled. He's damned on either side. And so the contestation continues. Now, what sort of ethical thought and practice does Ely's theory seem to imply? What kind of moral tradition are we talking about? At least for Ely, I would argue, it's not utilitarian. He's not really interested in generally in courts weighing social costs and benefits. It's not deontological. He doesn't provide a list of rules or suggest that constitutional decision-making is simply a matter of adhering to the oath. Right? I think his theory is a theory of virtue. Throughout, he argues for certain dispositions that judges should have, dispositions that will help them navigate the problematics, even when they must make choices between sometimes two incommensurable goals. He proposes a virtue of judgment, I think, that is tailored to the problematics of American constitutional law. The reason Earl Warren is a hero, right, and not just a mentor or a colleague or a friend, is because Ely considers him to have embodied this virtue of constitutional judgment in thought and in practice. That Ely was participating in a tradition, one that is ongoing and irresolvable, should be cause for a modest amount of optimism. From up close, I agree with Larry. Constitutional theory discourse appears pretty moribund. The question du jour is whether some version of originalism is or is not our law. But really, most judges and scholars are not even that theoretically interesting, right? They just argue for whatever policy they prefer, and they use the modalities that Bob had identified long ago as tools to get there. The fact that we haven't advanced much beyond Ely's theory is not, however, a sign that the discourse itself is dead. It may be on the way out, but I think that'll only happen if we jettison one of the commitments of writtenness, popular sovereignty, and judicial review, and that seems pretty unlikely to me. What seems more likely is that we will keep muddling through, largely rehashing arguments Ely and others have made, more eloquently in many cases, because the tradition continues to serve a useful role in our society, and because despite concerns about the political process that has led to the appointment of some members of the Supreme Court, the shared commitments are not seriously up for grabs. The tradition framework of understanding and evaluating constitutional theories, this framework of moral tradition I'm suggesting, has several important implications, I think, for the current state of our discourse, though. The first is that it has more integrity than some of us get credit for. From any given vantage point within the tradition, it may appear that participants advance theories or arguments that are fundamentally incoherent, leading perhaps to incoherent rulings. At a higher level of generality, however, the tradition is in fine working order. More so than many scholars would like to admit, the terms of the debate have not changed much in 40 years. This leads to another implication. Perhaps we should be a little less suspicious of those who disagree with us. Some theories are better than others, and surely one's values affect one's preferred theory. No one participates in the tradition as a moral blank slate. Each of us has histories, communities, beliefs that shape our approaches to constitutional law. While the tradition does not lead to determinate outcomes and even produces incommensurable views of judicial review, it does constrain theorizing. Put simply, we're all playing the same game. We should expect others will play with candor and ideally with a degree of self-awareness and modesty, but of course there'll be cheaters too. What we should resist is jumping from the existence of disagreement to the conclusion that our opponents are operating in bad faith. Finally, while the problematics of the tradition cannot be solved at one time, altogether they suggest a criteria for evaluating the relative merits of competing theories of judicial review. The most successful will always be those that maximize coverage, that come the closest to resolving the problematics. On this score, Ely's is one of the best. Others have offered thoughtful alternatives with greater or lesser degree of success. Jack Balkin and Jamal have both offered subtle attempts to take the Constitution's writtenness seriously while acknowledging the duty of courts to give some meaning to more open-ended rights provisions. Dick Fallon and Michael McConnell have proposed nuanced hierarchies of interpretive modalities. Stanford's Pam Carlin and to some extent Jane too, I think, have largely built on Ely's foundation. And of course, there will always be those like Larry who simply reject one of the commitments. Like, that's not totally fair. You reject supremacy, not review. But it's up to each of us to decide who's most persuasively resolve these problematics or whether we even care about the game at all. I want to now pivot away from meta theory and focus on a particular application of Ely's theory that he doesn't talk about much. He doesn't talk about the religion clauses very much. And what he did say suggests he found them kind of a puzzle for his theory. He seemed to think that reading the Establishment Clause as a structural provision had little to say about the political process. And though he acknowledged that the Free Exercise Clause protects a substantive value, he turned too quickly to argue that it should be read merely as an equal protection provision. So I think he missed a gold mine for his theory, actually. And I think contemporary approaches to religious liberty have a lot to learn from his book. Any approach to the religion clauses has to begin before them with the two provisions of the original Constitution about which democracy and distrust is entirely silent: the religious test clause and the oath clause. In case you haven't read them yet today, they provide that senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. This is Article 6, Clause 3. The oath or affirmation requirement may at first blush not even appear to have anything to do with religion, but it does. The clause was the first federal religious accommodation. It was an accommodation for religious minorities who could not conscientiously take an oath, but who could make an affirmation. The rule against a religious test as a qualification for office operated like a mini establishment clause. It ensured that no one would be excluded from office because of religion. Religious tests were one of the hallmarks of a religious establishment. The best way to ensure the government would continue to favor one religion and to promote religious uniformity was to withhold political power from dissenters. Together, the affirmation accommodation and the rule against religious tests are two of the most important representation reinforcing provisions of the original Constitution. America was a wildly religiously pluralistic society for its day and age. And although Protestant groups may seem the same to outsiders, they didn't seem that way to Americans during the early Republic. But these provisions also protect the substantive value of religious liberty. Religion, as the founding generation understood it, was mutable. It was a matter of conscience, which involved a complicated brew of reason and faith and choice. Of course, some religions are also bound up with immutable characteristics, like ethnicity or national origin. Even many of those, however, have mutable characteristics too. Right? Not all Jewish Americans believe the same things or engage in the same practices, and so on and so forth. The mutability of religious belief and practice explains why two provisions that seem like quintessential safeguards of political equality also reinforce democratic integrity and personal freedom. Like religious tests and oath requirements not only prohibited some from full participation in politics, they also created a powerful inducement to conform to the established religion, or perhaps worse, to pretend to conform. Virtually every hallmark of an established religion promoted religious uniformity at the cost of religious liberty, communal integrity, and social trust. The Establishment Clause extended the function of the oath and religious test clauses to all of the legal incidents of an established religion that distributed benefits to conformists and burdens to dissenters. by prohibiting forced tithes, government-controlled doctrine, interference with church governance, prohibitions on dissenting worship, and other laws. The clause, coupled with parallel movements of disestablishments in the states, because the clause only applies to the federal government, removed the legal burdens that prevented dissenters from full participation in government, while eliminating incentives to alter religious beliefs, practices, and community structures. This account of disestablishment makes sense of important Supreme Court cases that Ely totally ignored. The school prayer cases, for instance, really aren't explicable as free speech or free association cases. Unlike in West Virginia versus Barnett, which was the flag salute case, the students in Engel versus Vitale were free to opt out of the prayers. Neither did the cases involve special burdens on a disfavored religious minority. The school created and offered the same prayers for students regardless of their religion. The problem was that the government authored the prayers and used compelled school attendance to push students towards religious conformity. This account of the Establishment Clause also supports the court's current approach to government funding of religious schools. So long as the funding is religiously neutral, doesn't push parents toward religious schools, it doesn't threaten the religiously homogenizing tendencies the Establishment Clause foreclosed. I think the oath, religious test, and establishment clauses would have been really fruitful areas for Ely to have explored further, and they might provide a useful template for thinking about the relationship between the Constitution's express protection of substantive values, in this case religious liberty, and the representative reinforcing judicial activism that he favored, which is a puzzle that several other folks have talked about. Just a few words about the free exercise clause. Ely was right that the clause protects a substantive value. He said it was religion, but that's not quite right. It protects religious liberty. The difference is important because everybody has an interest in religious liberty, perhaps especially those who are free thinkers or otherwise not religious. Ely was also right that the court has generally used an equal protection kind of analysis to protect the substantive value of religious liberty. And this makes a great deal of sense, I think. America, especially now, I would say, America has a checkered history with accommodating religious dissenters. But from the beginning, there was a practice of exempting at least some religious objectors from some types of legislation. As mainline and evangelical Protestants gradually lost exclusive control over the switchboard, the nation became more religiously pluralistic. The nation has adopted thousands of religious accommodation laws. Some of them are general, they apply to any religion, any law. Some of them are specific, they apply to a particular practice, particular legal obligation. The norm, one might say, has become that the lawmaker will ordinarily exempt religious objectors if it's possible. When the lawmaker doesn't, it's usually because the objection was overlooked, because it was a good non-discriminatory reason the law has to apply to religious objectors, right? Or because a prejudiced motive affected the process. Of course, the last two are not mutually exclusive. There could be a good non-discriminatory reason to deny an exemption and a degree of prejudice against the objectors because the political ends are prejudiced against them. So it makes good sense to be suspicious of prejudice, I think, when a lawmaker declines to provide a requested accommodation. Here, I think Ely's suggestion for rooting out impermissible motives and prejudice are helpful. I would only add a couple points. The first is that an accommodation is a remedy for religious discrimination that is not nearly as judicially intrusive into the political process as is invalidating a law for discriminating against a protected class, right? The remedy suits the problem, which is one of religious liberty, not one of deprivation of a benefit on the basis of being a member of a class. And under current doctrine, at least, courts will not order an accommodation unless doing so will not undermine, in the court's view at least, a compelling government interest. The cases certainly involve value judgments, especially when religious liberty is pitted against the interests of other private parties. And they undoubtedly have symbolic power in the culture wars. But the judicial intrusion into the democratic process of simply ordering an accommodation is relatively minimal. The second point I would make is that sorting out improper motives against religion will often be trickier than for other suspect classifications because religion is so socially complicated. Consider several factors. So first, religious differences largely correspond now to party polarization. So in some cases, religious prejudice is impossible to divorce from political prejudice. Second, for some people, religious belief and practice correspond to an immutable characteristic, like ethnicity. So sometimes it's hard to distinguish between prejudice against the religious beliefs and practices and prejudice against their race or ethnicity. And sometimes it's the same thing. Third, for many people, religion is at least partly a choice. Remember, I said it's mutable in many cases. I would suggest that this raises the risk of what Ely calls self-aggrandizement, the tendency of the political ends to think better of themselves than they should. In this case, the tendency to assume that the religious conclusion you have come to is the right one, and the other benighted souls should get with the program. Fourth, polling data only goes so far in sorting out who the ins are and who the outs are. Because prejudice about a particular religious opinion may be higher, in fact, among co-religionists than between members of different religions. Right? Sometimes co-religionists are the most judgmental of their co-religionists. Fifth, because religious demographics are different across the country, the political dynamics that lead to religious discrimination are often highly local. Sixth, there's only six, just for those of you who are still awake. Sixth, some people feign religious beliefs to get an accommodation, and courts have not done a good job, I think, about adjudicating religious sincerity. They should do a better job, especially as accommodation claims become so attractive to some people, largely for seeming to be political purposes. I think the court did an outstanding job applying an equal protection framework to root out religious discrimination in Lukumi Babalu IA, the Florida sacrifice case. I think it's done a pretty lousy job in some recent cases involving the religious liberty rights of death row inmates. I think it's been miserable. While I don't agree with everything the court has said and done in the COVID shutdown and vaccine mandate cases, I do think the justices were generally right to be attuned to the possibility of religious discrimination, even discrimination against groups that in some parts of the country do have enough political clout to avoid having to ask for an accommodation at all. So thank you very much for listening, and look forward to chatting later.
All right, well, first of all, let me just echo the thanks to Michael and Morgan for including me in this wonderful conference. It's really an honor to be here. So I, like others here, I admire and basically agree with Ely's project in Democracy and Distrust. I think it's still in many ways the best theory of judicial review on offer. But I think the central political pathologies today are different and require a kind of different orientation for judicial review than what Ely proposed. And in particular, although I certainly don't deny that there are significant prejudices and inequities in society today, I think the central political process challenge at the moment is not actually the systematic exclusion of any particular groups from the give and take of politics. Instead, the central challenge is really the give and take of politics itself, and the way that rising polarization is encouraging a kind of prioritization of outcomes over processes and a resulting kind of reciprocal degradation of structural protections and civil liberties. And I think in that environment, Ely's prescriptions can actually be counterproductive for some reasons I'll come back to. And I think the better judicial response is something I've called symmetric constitutionalism. It's that courts should self-consciously, when possible, favor understandings that simultaneously protect interests on different sides of the ideological spectrum. So in other words, I think polarization encourages everyone to frame constitutional debates in sort of zero-sum terms as a kind of continuation of politics by other means. But courts should strive to interrupt that process and do the opposite, and try and spread out constitutional law's benefits so as to reinforce shared commitments and hopefully encourage partisans to view each other's freedoms as a reflection of their own, as a kind of have a shared stake. Now, I'll try and explain how that would work in practice, but just to give an example at the outset, I think the kind of First Amendment principle of viewpoint neutrality is paradigmatically symmetric in this sense. It protects all speakers regardless of ideological position. By contrast, I think the holding in Heller, recognizing a Second Amendment individual right to bear arms, is paradigmatically asymmetric. It constitutionalizes one ideological position in a salient debate at the expense of the other. And that doesn't necessarily mean that Heller is wrong. I'm envisioning this symmetry principle operating more as a kind of preference than a hard and fast rule. But my claim is that asymmetry is costly in ways that resonate with Ely's theory under current conditions. Okay, so let me start with kind of some shared premises or things I think Ely got right. So basically, like Jamal, I think his opening critique of both interpretivism and non-interpretivism, which is sort of more or less what we'd today call originalism and non-originalism or living constitutionalism, is basically correct and hard to improve upon. And also, I think it's a dilemma that's still with us, and in fact extends well beyond the sort of rights questions he focused on to questions about constitutional structure. And I also think his basic solution that courts should interpret those open-ended provisions in light of a kind of broader commitment to resolve value conflicts through specified democratic procedures is elegant and persuasive. But so what's then the problem? I think so one problem, a longstanding critique, as was mentioned earlier, is that his kind of purely procedural approach is illusory, right? That extending his notion of representation reinforcement, at least going beyond the paradigm case of sort of African Americans under Jim Crow, it just can't be done in value-neutral fashion, right? The classic example, right? How do we know that burglars are not a systematically disfavored group without making a value judgment? So I'm not sure it's quite as devastating an objection as sometimes claimed, but I do think it's clear at this point that identifying groups in need of judicial solicitude is a game that both sides can play, and in fact is something of a bipartisan sport at this point. I mean, I think on the progressive side, really building off Ely, theorists and judges have extended notions of representation reinforcement beyond race to gender, sexual minorities, I think increasingly immigrants, criminal defendants, other disadvantaged groups. But I think conservatives have gotten into the Ely game also. I think, right, claiming in effect that elements of their coalition are beleaguered minorities needing judicial protection against hostile or unresponsive authorities. At the least, I think that's one way to understand this sort of expanding jurisprudence oriented towards protecting, for example, law-abiding gun owners, religious traditionalists, small business owners, farmers and ranchers, and so forth. Now, I'm not going to try here to weigh or contest, right, these various competing claims of grievance, many of which have considerable validity. But I think it's noteworthy that these competing claims haven't really arisen outside the political process, but rather within it, right? They've become organizing principles or organizing orientations for constitutional law, just as the two major national political coalitions have organized themselves around advancing much the same sets of concerns. So that brings me to what I think is the central problem with applying Ely today. I think Ely, particularly in the representation reinforcement argument, had a kind of Madisonian model of politics. He assumed that politics works through a kind of fluid, pluralistic competition between groups and interests. And in that sort of process, right, coalitions are constantly shifting. Groups that lose on one issue prevail on others. And then with that model in mind, Ely presumed that courts could pretty objectively identify groups that were systematically excluded and kind of boost their position. I think we can now see that 1980, when Ely wrote Democracy and Distrust, was the tail end of a period when that model of national politics was plausible. It captures, obviously, the systematic exclusion of African Americans under Jim Crow, but I think from a broader perspective, the sort of big tented national parties of the post-World War II era did enable kind of shifting coalitions on different issues to set policy. But since the 1970s, that structure has given way to a different one that's characterized by increasing polarization and animosity. Right? Instead of politics organized around shifting coalitions and interest group alignments, today all disagreements seem to get shoehorned into kind of rigid binary conflict between two camps that view each other with increasing fear and suspicion. So I think that's the challenge today, and it creates a very different kind of process problem from what Ely was worried about, right? The central risk is not so much that a durable majority will gang up on some particular minority or another, but instead the political system will sort of cannibalize its own underpinnings. There'll be, as I said, a sort of reciprocal disregard for constitutional restraints and civil liberties, and they get in the way of policy goals. And I think in that environment, the way courts can best protect the political process is to provide kind of rugged rules rules of the road for political competition. But to perform that function, it's essential that those rules not appear to stack the deck. I would suggest they need to be symmetric, right? We need doctrines that straddle key divides, and thus that we stand a chance of being sort of mutually self-reinforcing. So I'll turn to some examples in a second, but again, to be clear, I don't think this is going to work for everything, right? Right, as Ely put it, right, positive law is its claim, right? The Constitution is hardly neutral between all possible choices, but I do think this is a principle that could work, as I said, as a kind of preference, a sort of thumb on the scale, and in fact, that's a virtue, right? In a world of kind of robust judicial review and interpretive pluralism, different approaches for different judges, right? It's a value that people with different approaches could equally incorporate. I do think it also has one important general implication. I think some of the current justices, particularly Chief Justice Roberts, have shown some affinity to this impulse towards symmetry, but they've tended to do it, at least Roberts, in this very ostensibly restrained, minimalist approach to resolving cases. And I think that's actually exactly the wrong approach. For better or worse, constitutional law has its tentacles in many areas of life, and it's hard for judges to be terribly restrained. And so in that context, I think it's a better discipline for judges to anchor their decisions explicitly in kind of generalizable principles that they can make clear will have a different political valence in future disputes. So let me just, I know it's all a bit abstract, so let me just offer 3 quick examples and then look forward to discussion. So the first one is I think symmetry could strongly inform interpretation of the structural constitution. I think having clear rules about the relative powers of the branches and levels of government is quite important in structuring political conflict today. But again, for those rules that perform that function, they have to avoid a sharp partisan skew. And at least one good example here, I think, is the anti-commandeering doctrine, right, that insulates states from, or gives states the autonomy to refuse to aid in enforcement of federal law. So, this doctrine is quite disputed as a matter of first principles, but at least has the virtue of symmetry, right? It's equally enabled blue states and cities to set up immigration sanctuaries during the Trump administration. Today is empowering Missouri and other states to limit assistance of federal firearms enforcement. So, as a policy matter, I don't much care for the sort of reciprocal degradation of federal law as force that these examples are giving rise to, but it does at least illustrate how there's a doctrine that implements a kind of core constitutional value of federalism in a way that's amenable to relatively even-handed enforcement by courts across different contexts. Okay, so that's one example. A second one, to build off Nathan's discussion, I think is religious liberty. The current court has seemed intent on expanding constitutional protections for religious liberty. I think many of its cases seem motivated by concern that religious groups are suffering a kind of hostility in the political process that warrants protection on Elian grounds. I'm sympathetic to that impulse, but I think that framing it the way the court is doing is a mistake because religious liberty is not a symmetric doctrine under current social conditions. Religious freedom was a symmetric value and the great majority of Americans were observant. But today, the religious left has dwindled to the point where I think battles, a recurrent axis of conflict is between kind of secular progressives and religious traditionalists. And so in that context, right, giving priority to claims of religious character risks making those conflicts worse, perhaps even fueling the kind of secular disdain for religion that the court is ostensibly trying to combat. So I think it would be better to build out, if the court is going to try and protect these groups, it would be better to build out broader notions of expressive and associational freedom that could apply equally across those divides. Okay, and then a last hot button example, as I think symmetric constitutionalism should inform how the court approaches unenumerated rights. As you all know, court this term seems likely to overturn or at least greatly reduce the constitutional right to abortion. As was discussed earlier, Ely, famously or notoriously, criticized Roe versus Wade, identified abortion as a question that constitutional law should have left to the political process. But I think if the court is now going to take Ely's advice on that point, in doing so, it faces an important choice about whether to make unenumerated rights doctrine as a whole more or less symmetric. The court could abandon the field altogether, but it probably won't, because there are other unenumerated rights, for example, parental rights, rights to educational choice, that, if anything, are more important today to conservatives. And so overturning Roe while leaving those other protections in place could appear asymmetric and hypocritical. So I think whatever path the court takes on abortion, symmetric constitutionalism, this value, should encourage it to explain what overturning Roe implies for other rights and embrace some general theory that won't involve just constitutionalizing the justice's current policy preferences. So just to sum up, I think there's a lot that's still important and valuable in Ely's effort to organize judicial review around protecting minorities in the political process. But today, somewhat ironically, I think the best way of doing so is not to single out groups for particularized protection, but instead to try and anchor those groups' protections in more universal symmetric understandings with the hope that they could be mutually reinforcing across partisan divides rather than contributing to further polarization. So thanks again, and I'll look forward to discussion.
I think we can take time for maybe 2 questions, so bring them on.
Wondering what you thought about the value of theory and meta-theory in terms of democratic values and deliberative process. So looking at constitutional theory, not just in terms of the substance, but articulation of democratic values, democratic debate, particularly in a global context.
I can try. So that's a broad question, and I'm not sure I'll be able to do it justice in this amount of time. One thing I would say is that I tend to think that the assumption that resolving conflict through a judicial process requires resort to some particular theory or meta-theory is question-begging. I think that resolving conflict through adjudication requires principles of political organization. That might be theoretical, and there might be some theory behind that, right? But it's not a theory about, it's not an interpretive theory, right? It's a theory of politics. And so we have to understand the choices that are inherent in describing the judicialization of conflict through interpretive theories as opposed to through theories of distribution of power and so forth. So my ultimate guide is to try to make those choices as transparent as possible so that we can all make them together. But I don't know if that's fully responsive to this rich question.
Yeah, I would just add that I think that democratic theory, whether it's to the extent decision makers are aware of theory, they have an implicit idea of democracy and what popular sovereignty entails that affects the way that they decide constitutional cases. And so that plays a part of it. I'm not sure that turning to theory would necessarily help resolve their disputes, because there's a lot of dispute about what democracy requires and why it's valuable, what its aberrations are. And it seems to me like people are likely to gravitate towards the one that reinforces their preferred values. So yeah, those are descriptive thoughts, not normative ones. But.
Maybe just add one thought there. I actually, during the earlier discussion, I was thinking about the way that there's often a challenge for totalizing theories is that our system works through case-by-case adjudication with, a strong norm of stare decisis. And so you can have generalized theories that might make a lot of sense if adopted wholesale, but as Dean Kramer was describing, where we tend to have, we kind of end up with a kind of pragmatism because you often can't do that through the system of adjudication we have. So I think theories can be very important, but in day-to-day adjudication, you often kind of fall back on a more kind of pragmatic sort of reasoning.
You can tell when the reception is beckoning, the questions begin to dry up. But I'd like to just thank this panel. So I thought that was extremely stimulating. And thank the handsome gentleman on the screen for providing this occasion, and invite everyone outside for a reception at which the various speakers will be there. So feel free to ask all the questions that you didn't ask at the microphones.